question, and that as a result she may have suffered damages as may have been shown in the proof. If you find from the evidence and believe from a preponderance of all of the evidence that the collision did happen as charged in the complaint of the plaintiff, then it would be your duty to find in favor of the plaintiff. But if the plaintiff has failed to prove by a preponderance of all of the evidence that the defendant was guilty of any negligence in any one or more of the particulars charged in the complaint, or if after consideration of all of the proof you find them in equal balance as to the way and manner in which the collision did occur, then in that event, if you so find, your verdict should be in favor of the defendant. It may be stated as a general rule of law that every driver of a motor vehicle owes the duty not to drive negligently. Therefore, before the plaintiff can recover in this case, she must prove by a preponderance of all the proof that the defendant she has sued is guilty of an act of negligence as charged in the complaint within the eyes of the law. In everyday language, the plaintiff must prove that the defendant was at fault or at blame for the collision, and that such fault or blame was the direct and proximate cause of the injury of which the plaintiff complains. Negligence is defined as the failure to use and exercise ordinary care. That is the care that a reasonable, cautious person would use or would have used under the same or similar circumstances. Of course, you would understand by this definition that negligence may consist of doing some act that an ordinarily careful and prudent person would not have done under the circumstances. By these definitions, you would also understand that ordinary care is a comparative term, and what is required by it depends upon the facts of each particular case. Ordinary care means such care as is commonly exercised by the majority of the persons of ordinarily prudent habits in the community when placed in similar circumstances. If the concurrent negligence of two persons combined together results in an injury to a third person, he or she may recover damages of either or both, and neither can interpose the defense that the prior or concurrent negligence of the other contributed to the injury. The rule is well settled in this state that if an injury occurs from two cases, both due to the negligence of different persons, but together constituting an efficient cause, all persons whose acts contributed to the injury are liable therefore, and the negligence of one does not excuse the other. In a suit based upon actionable negligence, the law imposes upon the plaintiff to prove by a preponderance of the testimony, first, a duty which the defendant owed to him, second, a negligent breach of that duty, and third, an injury or damage either to his person or property as the direct or proximate result of such breach. By proximate cause, it may be said to be the act or omission that causes or fails to prevent the injury. It is an act or failure to act occurring with another, which had it not happened, the injury would not have been inflicted. It is a cause of which the injury is a natural and probable consequence. It is the duty of an operator of a motor vehicle to keep a reasonable, careful lookout ahead, to see the objects and things that ought to be seen, and the exercise of reasonable care should have been seen, to be reasonably vigilant, and to anticipate the presence of others, to give timely warning of his approach if necessary, to drive at a speed not excessive under the circumstances and not in excess of the legal speed limit established for the place or zone of his travel, to keep his vehicle under reasonable control so as to stop it within a reasonable degree of quickness so as to avoid an accident. In other words, to do every prudent act or thing necessary or reasonably calculated so as to avoid injury. The plaintiff has alleged that the defendant's automobile was not under control. A vehicle is under control within the meaning of the law when it is moving at such a rate of speed, not in excess of legal speed limits, and the mechanism and power are under such control that it can be brought to stop with a reasonable degree of quickness under all the circumstances. Therefore, if a driver by the exercise of due care anticipates danger from another vehicle, it is his duty to operate his car so that it can meet the obligation of law requiring a vehicle to be under control. The plaintiff has defined and set out in her complaint the grounds upon which she seeks a recovery, and you cannot go beyond or outside of these grounds as they have been stated. As of an act. Okay, this is literary RPR 180. Ready? It is a great honor for me to be here this evening, and I appreciate the opportunity of attending the third annual banquet for the Outstanding Law Enforcement Officers of the Year. It is a pleasure to return to Birmingham. The 3 years I spent here as special agent in charge of the FBI's office are among my happiest memories in law enforcement. That is when I met many of the police officers here tonight. I am grateful indeed for the splendid assistance which Alabama law enforcement has given the FBI over the years. As FBI Director, I pledge to you continued close and personal cooperation. I want also to extend my sincere personal congratulations to each of the officers being honored tonight. You are a credit to your profession, and nothing could be greater than to be selected for this distinguished award. For you, this is the result of years of dedication, sacrifice, and faithfulness to duty. We are proud of you. You bring honor to all of us in law enforcement. Also, I want to say thank you to the citizens of Alabama who have made this event possible. Having been a law enforcement officer for over 30 years, I know what this occasion means for these brave men and women. They appreciate your interest, concern, and support. Your banquet tonight symbolizes that spirit of warm fellowship which must exist between the officers of the law and our citizens so that you may obtain the high quality of protection you deserve. I want to share with you this evening some of my thoughts and ideas on what makes a good officer and what are the qualities which make a man or woman in blue a top flight officer. All too frequently we expect of the officer what we do not require of ourselves. He must, in our eyes, be above reproach at all times, be honest and without a fault. He must make no mistakes, and if he does, we criticize him. We expect him to handle all situations in a competent manner, but seldom do we realize that we have not provided him with the professional training needed to handle our changing society of today. We expect him to risk his life to apprehend a hijacker, bank robber, and murderer, yet we often fail to pay him a livable salary and make few, if any, provisions for his family in case of death during the line of duty. We expect him to be enthusiastic and never complain, yet we refuse to take the time to acquaint ourselves with his working conditions at headquarters, the precinct station, or wherever he may be. We expect him to perform at top efficiency for long hours, often being called out in the middle of the night or on weekends, and forget that he too is human, that he gets tired and hungry, and like us, he may have a son with whom he would like to play baseball. We expect him to immediately take care of our desires when we call the police, forgetting that we have not given the chief sufficient manpower and equipment to provide the kinds of service we expect and deserve. Yet these men and women in blue, despite these handicaps, perform so well that I think the citizens across the great state of Alabama and the nation owe them a tremendous debt of gratitude. I have worked with police officers all my life. I have been an officer myself. I know their complaints and I know their joys. I think I know the men and women themselves as human beings. And I can tell you honestly and truthfully, you will never meet a finer group of Americans. They work not alone for the salary. If they did, they wouldn't be there. They work not to be heroes. If so, they would long ago have resigned. Now, they walk your streets, safeguard your homes, keep your traffic going. Why? Because they believe in the dignity of the law, in the triumph of right over might, and above all, because they want to do their share in helping protect their cities. These are the qualities shown by these officers tonight. I do not know any of them personally. I don't need to, because I know the traditions in which they believe: service, personal integrity, and courage. It is not always pleasant to be a police officer. There are many groups and individuals who hate the police, who call the officers vile names. They seek to discredit our profession. It takes a man of unique qualities to do his job honestly and faithfully. The excellent record of our officers in meeting these situations is a tribute to their training, skill, and patience. In today's society, the physical risk of being a police officer is high and is growing. Last year, for example, 134 brave officers lost their lives from criminal action. This is the highest total ever recorded. For the officer, death is possible at every moment of the day. It may come from stopping a motorist. We need to become better acquainted with our police department and its officers. We need to know more about the cancer of crime in our cities. We must be more ready to personally do our share to help make a crime-free society. is the 200 RPR jury charge. 200 RPR jury charge. Ladies and gentlemen of the jury, you have heard the evidence in this case as well as the arguments of counsel. At this stage of the trial, it becomes my duty to instruct you as to the law applicable to the issues in this case. When you have listened to these instructions, then it becomes your duty to consider the evidence bearing upon these issues to determine what the facts are and to apply to those facts the law as given to you by the court. The court is the sole judge as to the law applicable to the case. It is your duty to take that law as given to you by the court and to apply it to the facts as found by you. You are the sole judges of the facts of this case and what is proven by the testimony. It is your duty to determine from all the evidence what the true facts are and render a verdict based upon those facts as found by you. It is a rule of law in a criminal case that the defendant starts in the trial of the case with the presumption of innocence in his favor, and this presumption continues with him throughout the course of the trial until you have reached a jury room and have arrived at the conclusion that the people have proven their case and that the defendant is guilty beyond a reasonable doubt. The mere fact that he is here on trial, that he has been brought into court by criminal process, should not be considered by you as in any way removing the presumption that he is innocent. In order that you may clearly understand the burden which rests upon the prosecution, which is to prove the defendant guilty beyond a reasonable doubt, I will give you a definition of that term, reasonable doubt. A reasonable doubt is defined as a fair doubt. It is not an imaginary or possible doubt, but a fair doubt based upon reason and common sense. It is such a doubt as may leave your minds after a careful consideration of all the testimony in the case, in that condition that you cannot say that you have an abiding conviction to a moral certainty of the truth of the charge here made against the defendant. The defendant in this case claims the defense of what we call an alibi. This means in simple English that he was at another place at the time of the commission of the crime. I instruct you that this sort of defense is a proper one and is as legitimate, if proven, as any other defense. It is a defense that is easy to prove and difficult to disprove. However, the burden is not on the defendant to establish his defense absolutely, but it is such if the evidence upon the point raises a reasonable doubt of his presence at the time and place of the commission of the crime charged. You should consider all the evidence bearing upon the defendant's alibi and carefully examine it. If in view of the evidence you have a reasonable doubt as to whether the defendant was at the scene at the time the crime was committed, you should give the defendant the benefit of such doubt and find him not guilty. You are the sole judges of the credibility of the witnesses, the weight of their testimony, and what facts that testimony tends to establish. You have observed the witnesses on the stand. You may consider their manner of testifying, their apparent candor or lack of it, their possible interest or lack of interest, and after considering all the facts and circumstances, it is your duty to try to arrive at the real truth and facts of the matter. In this connection, I instruct you that if you find that any witness has willfully testified falsely as to any material fact, a material fact means a fact bearing upon the guilt or the innocence of the accused, you have the right to reject his or her entire testimony unless it is supported by some other witness whom you do believe. The defendant in this case has become a witness. This is a privilege which the law gives to him. His testimony is to be tested by you the same as that of other witnesses, and if his testimony is rational, natural, and consistent, it may outweigh the testimony of other witnesses. In this connection, you have a right to take into consideration the interest which he has in the outcome of this prosecution. During the course of this trial, both attorneys have, from time to time, made objections to questions asked of the witnesses. This is their duty as lawyers. You are not to assume that the attorney making such objection is attempting to withhold proper evidence from you, nor are you to assume that the ruling of the court, either for or against such objection, reflects any opinion of the court in connection with the events of this case. There is certain evidence that is not permissible under the laws of this state, and it is the attorney's duty to make objections wherever it appears to him that a question may be improper. The arguments and opening statements of counsel are not evidence, and in this case I instructed you that if any of the arguments of counsel or the opening statements made by them do not conform to the facts as you determine them to be from the evidence, then You disregard that portion of their argument, which has not been supported by the evidence. It is not the duty of the court to express an opinion on the evidence produced here before you, and you will be guided solely by the evidence and the facts as you find them to be. The defendant is entitled to the individual honest judgment of each of you jurors based upon the evidence in this case. Okay, this is 225 RPR 2 voice. Please state your name, Joseph Bell, and what is your address, sir? My home address? Yes, 2215 South Franklin Place. And you are employed by the City of Springfield as a police officer, is that correct? I am. For how long have you been employed? Approximately 5 years. During those 5 years, what have your assignments generally been? Routine squad patrol, general assignments. During the course of those 5 years, Officer Bell, have you had the occasion to make arrests for speeding? Yes, I have. And approximately how many such arrests did you make with the use of a squad car and the clocking method? 200 or 300, I would say. 200 or 300, I would have no real idea. But that's just an estimation. It could be more, it could be less. Officer, directing your attention to the 19th day of March 1973 at approximately 4:15 a.m. of that day. Were you on duty at that time as a police officer? I was. And did you have occasion at that time to be patrolling in the City of Springfield? I was. Did you also have occasion at that time to observe the defendant in his automobile? Yes, I did. Where, if any, was the defendant when you first observed him? At South 10th and West Main Street. South 10th and West Main Street? Correct. And what, if anything, did you observe about the defendant? At the time that you first saw him, I observed him going west on Main. And was the defendant on foot or was he in a motor vehicle, officer? He was in a car. Was he the driver of the car? Yes, he was. You could see this? Yes, I could. And he was driving west on Main Street? He was. And where, if any place, were you at that time? We were approximately mid-block of South 10th Street. What, if anything, did you observe then, officer? We observed a car go through the intersection at a fairly high rate of speed. And what, if anything, did you do then, officer? We went down 10th Street to the intersection to where we could see the car again. And what type of car, if any, did you observe the defendant in? A white 64 Ford. And what, if anything, did you do then? We turned down Main to go after the car. And what direction were you proceeding at that time? We were going west on Main. And where, if any place, was the defendant's car at that time? At South 10th and West Main. And what, if anything, did you observe the defendant do at South 10th and West Main? He made a right-hand turn to go north on South 10th Street. And what, if anything, did you do at that time? We went after him, and state whether or not you also made a right-hand turn on 10th and Main. We made a right-hand turn on 10th to go north from Main. And what, if any, street was the defendant's car traveling on at that time? South 10th Street. And what, if any, street was your squad car traveling at that time? South 10th Street. And what is the numerical 100 block of West Main Street and South 10th, officer? The north side is 1600, the south side is 1700. And as you proceed in a northerly direction on South 10th Street, do the house numbers increase or decrease? They decrease. And what, if anything, did you observe then, officer? We observed the defendant northbound on 10th Street. As he got to the intersection of West Green Avenue, his brake lights came on. He started slowing down because there was a red light there. And what, if anything, did you do then, officer? We tried to catch up to him to get fairly close to him. And what, if anything, did you observe then? The light changed to green before the defendant stopped his car and he started out again. And then what, if anything, did you do? We followed him. And where, if any place, did you attempt to establish your position for clocking? As we got to the intersection of South 10th and West Green Avenue, the auto we were following was at South 10th and West National Avenue. And what is the distance between West Green Avenue and West National Avenue at that point, officer? Approximately a block. And then what, if anything, happened? I held that position approximately a block behind him. As we got to the intersection of South 10th and West National, the auto we were following was at the intersection of South 10th and West Madison Street. And what 100 block is the intersection of West Green Avenue? The north side is 1300, south side is 1400. And for what distance did you maintain this position behind the defendant's vehicle? To approximately the 1200 block. We were in the 1200 block, and the auto we were following was in the 1100 block. And what, if any place, was it that you pushed the clock? As we were in the 1200 block, approximately mid-block. So what distance, if any, was it that you maintained a clocking position behind the defendant's vehicle before you pushed the clock? Approximately 2 blocks. And at the time that you pushed the clock, what, if any, observation did you make with respect to any reading on the speedometer? I noticed the reading on the speedometer. Officer, what type of vehicle were you driving in the morning in question? A police squad car. And that squad car is owned by the city of Springfield? Yes, it is. And is it equipped with a speedometer clocking device? It is. And is the speedometer clocking device separate and distinct from the ordinary speedometer, which is considered stock on this type of vehicle? It is. What, if any, type of speedometer is your squad car equipped with, officer? It's a special police speedometer. It's calibrated and it is equipped to be stopped and locked at any given speed. And would you state whether or not this is the same speedometer that is delivered with the vehicle from the factory? It is not. This is a special adaptation? Yes, it is. All right. And at the time that you testified that you pushed the clock, what 100 block was that in? What 100 block were we in? We were in the 1200 block. What, if any, observation did you make of the special police speedometer at that time? We observed the speedometer was locked at 50. Okay, this is 180 RPR lit. Ready? Members and friends, thank you so much for inviting me to come back to Nebraska on this occasion. It is always a delight for me, as everything that was to be for me began in this state, in a country school, in a small town high school, and in this state's great university. How different life would have been for me, I often think, had it not been for that institution we call school and those people who make it go, the teachers. Your Nebraska and my Nebraska may lie in the very same geographic area as always, but the changes it has known since I was a day-to-day part of it, and it was the only world I knew, have been great indeed. Even the fact of going to work at this hour of the morning is a big switch. When I was growing up on the farm, anyone who was not up and doing by 5 in the morning was asking for the village banker to come and take it all. Before coming here and considering the kind of audience this would be, I looked in my dictionary for the word teacher. I knew what it meant in a general way, but I wanted to see what kind of word company it was keeping. That shook me up a little. It gave the word a total of 16 lines. Being at odds with the meager amount of credit given you by my dictionary, let me break the word up into the letters which compose it, and this will, I hope, explain to you the reasons why I feel as I do. First, there is the letter T. I would like to let that stand for technology, and this begins with teachers borrowing on the wisdom of the ages and adding new thinking. It calls for the addition of the important ingredient we call imagination. The next letter is E, and I would assign that to experience. One of the hardest jobs in teaching is to stay ahead, particularly if you are faced with bright youngsters in a classroom. Experience is not only the great learning aid of those being taught, it does things for the teacher too. We move on now to the letter A, and I would assign that to application. I have always felt that the greatest loss in the abortion of the Apollo 13 mission to the moon was not the crippling of the ship, but the denial of the world's classrooms of the conversations from mission control in Houston to the astronauts in the great mortal danger. Now the next letter up for consideration will be C. I give that to curiosity. This eagerness to know goes in many directions and shows in many ways. It can be as easily worn by the gossip who settles for half as by the most responsible newsman who wants to present all that is pertinent. It is the starting point for trying something new. The H is for horizons. These are too often accepted as being as far as one can see in any direction, but it wrongly assumes the viewer will always be in a fixed position. Movement changes it all, and by taking new positions, horizons can be altered a little or a great deal. The next letter is E, and I give that to example. I would like to tell you how my geometry teacher once saved my neck in a way not even she would have dreamed of. I was faced with a difficult technical assignment. The idea was to write about it in a fashion which would say it all simply and say it for the easy understanding of general readership. I checked with her about the theory. I remembered that two straight lines can intersect at but one point. I used that as my lead on that story, which ran nationwide. The last of the letters in teaching is R, and I ask you to think of it as standing for recognition. I have been told that through grade school and early high school, it is hard for most young people to believe their elders think they are worth the trouble, will ever amount to anything, will ever really be anybody. Recognition is the simple act of encouragement. I bring this up because somehow this ability or willingness to applaud others for good work is not there often enough for those who leave the classroom to carry it out into their own lives. You as teachers have probably steered a great many on a future course which would startle you if you knew some of the results. My hope is that those you did it with will remember where it will really begin and will let you know. My first teacher is still alive, but quite frail now. When they asked me to come back to my hometown once to do the commencement address, she made a trip of 600 miles each way to be there. I said I was glad she was there as I needed her on my first day of school. I just might need her again. No one enjoyed that special remembrance between us more than she did. While I can never say I was ever a teacher's pet, I can say that some of my favorite pets have been teachers. Bless you all. (190) Congressional Record. I remain deeply critical of the UN in spite of the hopeful events surrounding the opening of its 30th General Session. Because of these encouraging signs, I will expect a great deal more from this organization this year with respect to achievement of rational, practical, economic, and social policies. Presently in the UN, there seems to be an inclination among all members to work toward accomplishing realistic solutions for devastating problems. I am anxious to see how effectively the UN responds to this positive attitude. A few months' time should prove whether my critical attitude is justifiable or not. Mr. President, a pertinent editorial winning the fourth world appeared in the Wall Street Journal on September 26, 1975. It is a commentary on the opening session of the UN and, in my opinion, is on target as a thoughtful response to the potential for revitalization currently existing at the United Nations. I ask unanimous consent that it be printed in the record. Mr. President, before turning to the subject of oil and gas price regulation, I want to make a few observations about the conduct of present negotiations with Spain. Mr. President, the Western world has been shocked by the executions in Spain. We are brutally reminded that the exercise of tyranny is not restricted to the communist nations, but lives on in the only dictatorship to survive World War II. I do not condone terrorism. I accept one man's revolutionary as another man's terrorist. I do not challenge the right of any government to bring those to trial who are charged with murder, but I do